at least, thank you, Latana, at least with the beginning parts. Welcome everyone. As always, we're so glad for your participation. I understand that for many, this is essentially a volunteer opportunity. Not quite everyone, but I know for lots of us it is. So thank you for being here. As Elaine just said, in case you didn't hear, Judge Williford will be here with us shortly. I think her office has already signed in for her and she's just wrapping something up. So we'll see her soon. Latana, will you go ahead and address the meeting rules for us, please?
Yes, thank you, Katie. And good morning, everyone. I'm Latana Lawrence, and I am the program coordinator for the Georgia Child Support Commission. I will briefly discuss a few rules to help us navigate the meeting today via Zoom webinar. The statute reviews subcommittee members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. The Child Support Commission does not hear public comment during any of its subcommittee meetings. Accordingly, we will not be accepting public comments today. However, you may leave a written comment for the Commission at any time through the Commission's website. For your convenience, I will put that web address in the Zoom chat momentarily. Also, anyone wishing to give public comment by speaking may do so at any full Child Support Commission meeting, which the next one will be held on November 17th. And also, the Child Support Commission has a YouTube channel, and I will place the link in the chat so everyone can view this recording and previous recordings as well. Thank you, and I'll turn it back over to Katie.
Thank you, Latana. Okay, I'm thinking we don't yet have quorum for addressing the minutes. Does that sound right to you, Noelle?
Yes, exactly.
Okay. I'm wondering if for future, although we're hopefully wrapping up some substantive things, we should put the approval of the meeting minutes towards the middle of the agenda from now on, since we're almost always waiting on quorum to come in. And I feel like it's Groundhog's Day every time when I say, we don't have quorum yet. Anyway, and Judge Williford is here. Thanks, Judge Williford, for joining us. So we are about to move into Roman numeral 3 of our agenda for those who are following along on that paper, into the business of the subcommittee. Let's see. I have a schedule to start with low income deviation. I think, Judge Palmer, you're prepared for that. Judge Palmer or Judge Williford, do you have anything to add from a housekeeping perspective before we sort of turn it over to Judge Palmer and Dr. Venor to talk about low income?
No, thank you.
Okay.
Yeah, no, I think that, yeah, I've spent a fair amount of time on it the last couple of days. I think I know what I want to do. But I wanted Dr. Venor to go over, she had a number of scenarios that she had put in her memo that is dated September the 18th that I thought were helpful. And I had previously sort of advocated for the $1,500 after going over it, after looking at the memo, after spending some time on it, talking it over with the staff and some other members of the subcommittee, I've kind of changed my mind about that to 1500C, due mostly to the fact that I think it deals with situations where there are multiple children a little better. And I also think that a couple of people had raised an issue about maybe it going up too high. I think it goes up to $4,000 maybe before it phases in the regular chart. But in the real world today, that is not a lot of money if that's the gross income. So I really have kind of come around to think that might be most appropriate. But I wanted Dr. Venor to go over those I don't want to spend too much time on it. I want to make a decision today about what the subcommittee is going to recommend as far as this goes. I think we've kind of debated it enough and everybody's got enough information to make that decision. So Dr. Vanur, if you do that, just sort of go over I mean, you don't have to go over every one, but just, if you would, just go over enough of those scenarios, in particular, the ones on page 2, for my benefit and for everybody else.
Sure. Thank you, Judge Palmer. So if you want to see what we're talking about, the 15A and the 15B and the 15C, you probably want to refer to the August 14th memo.
Okay. I have
And
that.
there, and there we had 3 options, and all of them start with and I meant to change it. I'm not sure I did, but it's supposed to be 1,500 and less is the lowest income
Right.
that's considered of the non-custodial parent. And what we did on that line, and all 3 of them are the same, is one child's 19% of income, and that's based on that research that's quoted in the federal rule, the narrative. And then it goes staggered for 6 children up to 28%, because that's consistent with that research that's cited in the federal rule. I have issues with that research, but that's beside the point. But that's the bottom amount. So those 3 are the same between 15A, 15B, and 15C. The difference between those 3 is how we phase it out, because it really costs for 6 children, it costs more than 50% of a parent's income. That's what families typically spend. So we have to go from 28% to close to 50%. But as we get to higher incomes, they spend less and less. For instance, I know the numbers more off the top of my head for one child, but we see 19% of income for the lowest, for 1,500 and below. And then when we get to the real economic data, when we get to incomes that are, somebody has a 6-figure income per year, it's more like 10%, 12% of gross. So all these decrease. So it's how quickly we decrease to get to the actual amount that's spent on children. So 15A cuts it all off at 2,500. We're out of the low income table. So it's a pretty steep decrease to get to the Betts and Rothbarth. 15B, what we did was we took that percentages at the 15 and below, which is 19% for one child, 24% for 2 children is the vast majority. And we waited until the Betts and Rothbarth, once it's adjusted for gross income and all those other things we did, was less than 19% or less than 24%. And that's why you see that table B goes on and on, particularly for 6 children. Like if you look at the end of table B, it doesn't hit that 20% of gross income until we're in, over about 12,000 a month. I mean, that's not gross income. I mean, that's not low income. Even the Pew Foundation, they just released a study on what is middle class, and they say 75% of medium income should know that. So that's not even close. So it doesn't feel quite right. So 15B is kind of a compromise where we recognize that the economic data shows that it does cost more for 6 children, for a larger number of children, but we cut it all off at about 4,000. And
I'm sorry, Dr. Moore, I think you just it's 15C then. That is the compromise.
C.
Right. Okay. You had said B.
Yeah,
So,
C is the middle ground of the other 2, right?
Yeah.
Yeah.
Yeah, and you can see with 15C that where the Betts and Rothbarth come in varies by the number of children. Like, one child, by the time it reaches 2,500, we can go to the Betts and Rothbarth. It's actually less than 19%, but then we stagger the rest of it. So parents with incomes get a break, but it's not as big of a break or doesn't extend to as high of income as 15B. And that isn't what Judge Palmer asked me to do. He asked me to step through the case examples, and I ended up trying to explain in words the difference between those three.
No, that was great. That was really good.
You're very generous. So the reason for 15C is illustrated in case example. It is, I've got to find the page number. It's on page 4 of this is the September 18th memo. And if you look at the case example where there's 4 children, and I think somebody, I can't remember who was it that gave me this example, but you can see
S6 is it, right?
Yeah, you got it. So you can see that column 1 shows NCP share the existing BCSO table. So this is before any adjustments for low income or add-on. So if we go for the first scenario, NCP has more income. NCP has 3,000, and S7, the NCP has 1,740, but all the rest of the case characteristics are the same. And then under column 2, this is the BR, the new schedule that the commission favors. You can see that it would be 1021 for case S6, and for oops, I can't read that, 634 for S7. And then we can look at these different, column 3 is if we took the amount from the low income tables. So for that first S6, it doesn't even apply. If we took option 15A, because his income is 3,000, which is above that 2,500. But if we take that option 15B, which is the generous column, the maximum would be 780. And then if we took low income option 15OC, then it would be 1085. So it still applies. And then we have the whole issue of add-ons. And I'm going to assume here that the add-ons, that the last step would be applying the low income. And here we can see that there's a lot of childcare expenses, almost 1,000, 975. So the obligor's share of that would be 499. Column 5 shows that amount. If we were just to take column 2 plus column 4, which is how you would do it now, where you would take the schedule amount, the obligor's share of the schedule amount from column 2, add the share of the add-on, 492, it'd be 1512. That doesn't feel quite good because 1512 is about 50% of 3,000. And the reason that doesn't feel good is that we can't even collect that through income withholding because our CCPA limits it's a percentage of disposable income, which would be after health insurance and all those deductions. And it's roughly 50%, but more or less depending on there. So if we were to just apply the low income table, so do the last step, which would be column 3, if Georgia were to adopt option 15A, the NCP would have an order of 1512 because his income isn't in that low income table. If Georgia were to adopt 15B, his income, and this was the last step, it would be 780. And then if Georgia were to adopt low income 15C, his order would be 1085. And I know you haven't decided whether to do add-ons before or after, but this illustrates why 15C works better for those with more children. And we could do a case scenario without an add-on, but that just happened to be the case scenario that we have. I'm going to stop there and see what clarifications you might need.
No, I think I understand it. And one of my one of the things I'm thinking about, frankly, is sort of a bird's eye view of this and the politics of it. That, you know, some people are probably going to say $4,000 is not low income, you know, and shouldn't be considered low income. But I think we can make a pretty good case that it is. But I'm not sure if we were to adopt B that we wouldn't have an issue, because it goes up so far. Does that make sense? I mean, I know you don't probably care about the politics of it, but I think we need to think about that when we decide what we're going to adopt. Anyway, does anybody else have any questions or anything they want to say about it?
Judge Palmer, to your point, I think it's important to understand that it's not the point at which they're not all getting like a full 19% or 24% or whatever the percentage is. It's the point at which it finally fully phases out.
I understand.
Yeah.
I understand that. I'm just saying that I think somebody's gonna ask that question, you know.
Right. And I think it's important to understand it's the point.
Yeah.
It's the point where it finally fully phases out, and we're talking about it's at those higher income levels when we're talking about like 6 children.
Yeah, right.
It's not for one child. Right?
Yeah,
That's what's important.
yeah, absolutely.
Dr. Venor, I have a question for you. You're the economist. You are the expert that the commission hired to advise us. What is your opinion about which one of these would be preferable for Georgia, in your opinion? I know you don't make the decision, but give us an opinion.
Well, if you look at 15A and 15B, I mean 15A and 15C, one child and two child are exactly the same. And that's going to hit the bulk of your orders. And the way I always look at it is what makes the sense with the economic data and what makes the sense for the majority of the cases. So I would have to say that 15C makes the most sense for the majority of the cases. It's really no different than 15A for the majority of the cases. Where it does make a difference is for those cases where there's a lot of children, 6 children, and you know that's less than, what is it, of your caseload. 4 or more children is 2% of your caseload.
Yeah, that's unusual.
So yeah, so you know, I like the efficiency of 15A, but 15C does make a sense for those 2%. And then, you know, you might do a process of elimination. I mean, that might be a way to approach it. You could decide if 15B is even a viable option. It doesn't, you know, it's hard for me as an economist even to say that that's a low income when you get into over 10,000 a month.
Yeah, that I agree.
I can't
and
imagine.
That's why that's what I'm talking about when I say I think we need to at least think about the politics of it. That, you know, somebody's going to look at this and the legislature is going to have to vote on this. And those people are not economists or judges.
Well, I think it's smart to think about it because we can do all this work, but if the legislature doesn't buy into it,
they can do anything they want. I mean, we can draft the bill any way we want to, but I mean, they're not bound by anything we do. We've got to persuade them that
I'm convinced that 4,000 is low income. If you think about, you know, if you think about the fact that it's gross income and not, you know, disposable net income, and you think about the economy, and certainly Dr. Venor is the expert on the economics of it, but, you know, just thinking about the affordable housing crisis and folks who are trying to find a place to live, you know, even if you were low income enough to qualify for, say, Section 8 or HUD housing, you might be on a waiting list or 20 waiting list for God knows how long, right? So you are out trying to find a place to live, and You know, I know some young people who have a decent income who are trying to find a 1-bedroom, 2-bedroom apartment, not luxury apartment, but just apartment in Macon-Bibb County, which is one of the least expensive places to live compared to some of the metro areas. But, you know, you need $1,500, $1,800, right, just to have a roof over your head. And then you've got to have utilities, and you've got to have groceries, and you've got to have, maybe you have a car and insurance and all of these things. It's hard for me to understand how anybody who grosses at $4,000 a month could make it. I mean, I would have a hard time understanding how anybody would argue in today's economy that that was not low income. But I think that, you know, when you compare it to, say, the federal poverty level, it seems high. So I understand what you're saying, Judge Palmer, about the politics of it.
Yeah, and I think that, just, you know, in my mind, I'm however old I am, 54. If I think somebody makes $1,000 a week, that doesn't seem like low income just at first glance.
Right.
But when you break it down the way you did,
Yeah.
it is. I mean,
Well,
and that's somebody, I mean, that's what, $48,000 a year is
well, and like
a
Noel
truck
said, though,
driver. I mean, you know,
like Noel says, it's going to phase out. It's not going to be the full percentage.
That's right. Yeah.
And then and Dr. Venor says it really is going to apply, you know, mostly when you get to that level to the families that have multiple children, which is 2%, right?
Yeah. And by the way, for one child, which is most of the cases, there's no difference.
There's no difference.
Yeah. So,
right.
I have a quick question. I'm sorry, may I ask a quick question? I don't know if this is ignorant on my part, but when we talk about the statistics for, you know, those 4 and more, you know, 4 and more children, 5 and more children, are we talking, does our data tell us if those children are all from the same parents? Or are we just talking about orders where we know there are, you know, that many children who impact the order, for example, other qualified children? Or, okay, sorry, Dr. Venora, you're shaking your head. Will you just?
When we talk about the number of children, that's the number of children for whom support is being determined.
Okay.
So,
okay.
Yeah. And
so
then
presumably we're talking about the same parents then.
Right. So there might be more children that affects affordability. And
okay.
I'm using the term affordability because this really is, it's kind of a misnomer to call it a low income table. It's really an affordability table. Like if you look at the 15C and you look at the one child, if we go to the very top, it cuts out at an income of $2,450, and it's $467 at that point. So, and that's 19% of the NCP's income. And then all above the schedule, it's going to be less than that. If we look at for 2 children, the Betts and Rothbarth become affordable at $3,000, because you can see it cuts out right at 2,950 for the NCP's income, and at the dollar amount of the low income table at that point is $840, and that would be 28% of his income. And the problem is that those 6 children amount, I mean, it just costs a lot to raise 6 children. And when we get to that 3,950, which is when the 6 children cuts out, the low income table shows 1,774, which is actually 44% of his income, which is quite a bit. But when you know exactly what Judge Williford was saying, he's got 3,950 of income. We're asking $1,077 of child support under this table. So the rest of his income has to go to rent, food, and stuff. So it's affordability really changes depending at what income. It changes based on how many children he has. On the flip side is we have a custodial parent that needs to support those children. So, you know, we could take that 3,950 at 6 children and say, maybe we should only assess them 1,000. But, you know, there's, the other side of the coin is the custodial parent. I don't know if that helps. I'm going to stop there.
Well, we do know that studies have shown if we order something that is not affordable, the chances that they're going to actually pay it, decrease substantially, right? And so
Right.
I frequently say from the bench, if I order you to pay something, if I order if I order someone to pay something that they just cannot pay, the chances are you're not going to get anything. We need to do something that's actually doable in order to expect folks to pay child support. I mean, that's my opinion. Deborah's shaking her head no.
I think Judge Venor told us, I mean, not Judge Venor, Professor Venor told us 2 meetings ago that actually the newer studies have said, no, it's not the amount of the order relative to the person's income that's the deciding factor on whether or not they pay. The ones who mostly don't pay are the ones that got default orders where they didn't really know it was happening until after it was already over. And there was a second group, Dr. Venor, and I've now forgotten what the second group was, but imputed income, people within where the income was imputed. So it wasn't actually based on their actual income. Those are the groups where the payment rate is the worst. So we're not doing anything about payment rate by reducing child support orders.
You know, I got to,
sorry. Yes.
yeah, I got to clarify that. That's true of the California study, which was cited in the narrative of the rules, that the Orange County team, that they did a study back in, I think it was 2011, that is cited, or I think it was that was cited in the rulemaking. And then subsequently, Orange County came with another study that said income imputation and default matter more. But there's a whole bunch of other studies. You know, Maryland's done one. There's it's probably the Maryland. There's been Wisconsin. That I do think it tilts more to income imputation and default, but I'm not ready to say that's definitive, that percentages don't matter. I don't want to give that impression. Percentages probably do matter, but not as much as, in my opinion, based on the research, as much as it was stated in the rules, but in the federal rules. But I don't want to say that they don't matter.
Thank you, Dr. Venor. I have a question for you as well while you have your thinking cap on. What's the median household income in Georgia? Last I remember, it was about $50,000 a year, but that's a long time ago.
You know, I look at family income, so intact families. I want to say it's closer to, and nationally it's like 100,000 or something. So I want to say close to, yeah, for husband, wife with children, and Georgia is pretty close. It might be like 96. I'll look it up as we're speaking.
Okay. I am perhaps going to be the voice of the anonymous legislator that Judge Palmer was hypothesizing, and I'm going to say I'm concerned about the idea of saying that the Child Support Commission or this committee thinks that $48,000 a year is low income and therefore deserves to have only that person's income considered in deciding child support, and the income of the parent where the children are living is not relevant when somebody makes that much money or less. That concerns me. The optics don't look good to me. Back when I worked at legal aid, low income was considered to be between roughly about 150% of the federal poverty level, which is hugely far below the these kind of numbers unless it was a family with about 8 children. So I'm concerned about the idea that we seem to be willing to say in the legislation that that's considered low income. I understand that what it really is saying if you've got a lot of kids, we're going to give you a break, but only if your income is at or below $50,000. If you have a lot of kids and you have more than $50,000 a year, then we're not going to give you a break. I'm troubled by that. But
So Georgia's median income for married couples with children is $115,700, so about $116,000 a year.
okay, thank
So-
you, Dr. Venor. So
And
these numbers are
understand.
well below that, but still don't seem like low income to me, especially when what we're saying low income means is that we only look at the income in one household, not both.
You know, I understand what Ms. Johnson is saying, and I mean, all I can say is it's a mechanical issue. It's not a low income. It really is a misnomer to call this a low income table. It's an adjustment for lower incomes, I guess, or to keep it payable, because, you know, really for one child, it works out to be $2,500 a month, which is 200% of the poverty, you know, so it's just keeping it reasonable for 15C. You know, and I think I don't know if you're suggesting option 15A is a better option, you know.
I'm just looking at it. I mean, I don't know if these statistics are correct, but just a quick Google search of the income limits for Section 8 housing in Georgia. And the maximum income limit for a household size of 2 for Section 8 housing in Georgia is $50,100. And that's according to affordablehousing.hub.org. And this is a March 28th, 2023 table. So you qualify for Section 8 housing in Georgia for a family of 2 if your income is below $50,100. For a family of 4, it's $62,600. For just one is $43,850. So I just don't think $4,000 a month is too far off the mark when you're looking at comparing it to Section 8 HUD housing.
I think that's useful information, Judge Williford. I think it's also important for folks that don't deal with Section 8 normally to understand that the way it works is there's an income limit that's like the max you could possibly have and get any help from Section 8, but the amount of help you get could be as low as just a few dollars a month. And the higher the income is within the eligible range, the lower the amount of help is going to be.
And that's how I understood this to work, correct? So it would phase out the higher very much like what you're just saying, how Section 8 works, that if that's the maximum, it's going to phase out the decrease, you know, the higher you are on that scale. Is that correct?
I think that's right. I think the important difference is that in this situation, it's not that if there's a certain amount of income or a certain level of poverty, somebody gets some help from the government. What this group is deciding is at what point do the circumstances of the children in the custodial home stop affecting the amount of child support they'll receive. That's what this is about. And we're saying that once the income is at that level, then giving a break to the parent paying support is a higher value for us than protecting the child support that the children might need, depending on whatever the circumstances are in the home where they live.
All
And
right.
Dr. Lenore,
Does anyone else have any comments about the low income type?
Dr.
Dr.
Lenore has her hand
up.
raised.
Yeah.
Yeah. I want to flip the conversation a little bit. Just if you look at table option 15C, if you look at the one child, so it's when it at its maximum amount, it's at 2450 and the amount is 467. So that leaves the obligor about 2,000 a month. And if you look at the 6 children, the maximum is 1774 and that occurs at 3950. So that again leaves the obligor 2,000 to live at. So really it's the amount after the table is considered, whether that's a livable amount. And, you know, that could be arguable. You know, it's roughly 2,000 if you were to calculate it for each point. And, you know, that's another way you could adjust the table. I'm going to stop there.
Anybody else have any comments? All right, then I'm gonna make a motion that the subcommittee recommend to the commission that that we include low income option 1500C in the new revision of the statute.
Great. Shall we take a vote on that? Judge
I'll
Palmer?
second it. I'll second it.
Okay, let's call the vote then. Thank you. We have a motion and a second. Is there any discussion beyond what we've already had about the motion? Okay.
This is Judge Colbert. The only discussion I have, you know, and I'm hearing child support cases now for the last 2.5, almost 3 years. I don't know that we're going to find anything that is going to fit perfectly. The reality is I have a lot of these cases that come back under the current system on contempt, and I just determine whether the failure to pay is willful or not. And if I find that the non-custodial parent couldn't afford it, I don't find willful contempt.
That's correct. Yeah.
My only concern is that, you know, sometimes when folks have an amount that they feel like they can't afford and live, then they don't pay anything, which my conversation with them in court is pay something, you know. But that's just my 2 cents. I just don't know that we're going to find something to fit perfectly, because the other reality is some of my repeat offenders in terms of non-paying have other issues going on that I don't know that the study takes into account, like probation fees, fines because they're driving without a license, you know, because their license has been suspended for child support. So yeah, that's just my 2 cents. And I guess I've been less than vocal because I just don't know that we're going to come up with anything that fits what the law is trying to accommodate. Families that are not intact, parents who go and have more children and having struggles to support the children they already have. So I guess I'm going to support this because I don't know that there's anything else we can come up with that's really going to resolve the ultimate issues. And I think hopefully as judges, we'll just continue to do what the evidence, you know, and the law supports on each case as these cases come back. So.
And Judge Colbert, as a fellow judge, I'll say that, you know, my understanding is that there would always be discretion still under Schedule E or whatever schedule it's going to be. I'm assuming still Schedule E for a non-specific deviation, because you're right. There are so many scenarios that we see that just don't fall into some neat little category, and we could give, you know, 50,000 examples and we would never be able to find a solution that fits all of them. And so that as judges, we're still going to have the right for a non-specific deviation if something falls outside of the, you know, of the norm. Or at least that's the goal as I understand it.
And piggybacking on, you know, both Judge Colbert and Judge Williford's comments, you know, what we heard from Dr. Venor just a few minutes ago is that, you know, this is what addresses the majority of the cases, you know, and as I understood it, the vast majority. I just added the word vast. She didn't use the word vast, but I think, I think that's worth pointing out that, we are trying to propose something, or the motion proposes something that will address the vast majority of Georgia cases. And, the exception is always going to exist. Okay.
I think it's worth remembering that there already is a low income deviation in the child support law, and that what we're looking at here is eliminating that deviation and replacing it with this adjustment, which would be done automatically in any case where the numbers play out the way they are on the charts. And so I don't want people to make a decision based on, well, we need to do something, and there's nothing now. There is a low income deviation in the law now, and it is underutilized, and that's why the committees or the subgroups or whatever they are that I sit on got created, and why we're talking about this now.
The reality is, to say underutilized is probably a misnomer. It's rarely utilized at all. Elaine's shaking her head. I think the statistics have shown that it's rarely utilized. I don't know, people just don't understand it, or just don't do it, or don't take that extra step. But it's practically non-existent, even though it's in the statute.
Right, agreed. So I see one question before I call the vote in the chat. Johanna asks, am I correct that the table selected has no impact on what order the add-ons are addressed?
Correct. Right.
Yeah, I think
That's right.
Okay, so
that's a whole separate issue.
We haven't even addressed that. We're not talking about that at all.
Okay.
Yes.
So let me, that's right. So let me ask staff, do we have a quorum?
We do. We achieved a quorum of 8 about a little bit after 10, and we're now at 9. So we're more than enough to vote.
There we are, Groundhog's Day. We always get that quorum somewhere in the middle, or we always hope we do. Today we do. So I'm going to call the vote. So for those who are voting members of this subcommittee, if you would like to cast your vote in the affirmative to pass Judge Palmer's motion, Judge Williford's second, please vote now. Noelle, what's the easiest way for us to vote? You want us to put it in the chat? You want us to raise our hand? Tell me.
For me right now, if y'all can use that the raise your hand feature, if Judge Palmer might have a problem. I think he may be on a different.
I'm on, like I said, I'm on my phone, so I'll just raise my actual hand.
There we go.
Raise your actual hand, or do your little yellow, feature for the eyes, please. This is people who would like to vote in the affirmative for this motion. And Noelle, just tell us when you're finished.
I got a unanimous vote of all 9 subcommittee members in attendance. So thank you.
Okay, thank you. That motion passes, so that will go forward to the full commission. Thank you, Judge Palmer, for bringing that motion. That almost feels like, where's the champagne when you need it? We got that motion made and passed. So there we go. Thank you. Okay, do we need to do anything else on this agenda item, or can we move to the next agenda item?
Well, the same under the low income adjustment, but about the sequence now, correct, Katie?
I think that's right. But
yes.
Okay. So
we need to move to the sequence.
When you said next agenda item, I just wanted to make sure you meant. Yeah. Okay, go ahead.
Okay. So Judge Palmer, I believe you're addressing that issue too. Am I mistaken about that? The sequencing piece? No. Okay. Hold on. Sorry. I need to read my executive agenda more closely. Who is scheduled to address the sequencing?
Well, is it no, you're not, or no, you're not incorrect? I guess the better question is,
I'm not prepared to do that.
I see.
I can tell you what I think, but no.
I think Dr. Benor is prepared to speak on explaining the sequencing around the add-ons.
Okay.
Okay.
Okay, now we're back to the September 18th memo. And the first table there shows the sequence of how you do the steps. And you can look at this as hardwiring, you know, because this is what the people that are going to be drafting the statute really need to know to draft it up right. And I know you all have other decisions like how to define overnights. That's more like the trim, you know, it's really important. It's what people see up front, you know, it could be the carpet or the kitchen counters or whatever you use, but that's something that can be changed. Like if you were to change the 4 hours or whatever you want to do pretty quickly for this people that are writing up the statutory changes. But this is really the hardwire, the electricity and where, you know, to make it work. So that's the reason.
Excuse me, Dr. Bernard, just to orient everyone, are you on the first page of the September 18th memo? That's what it looks like to me. Okay, just making sure we're on this all in the same place.
So the things that we have going in the sequencing is when to calculate the parenting time adjustment, when to calculate the low income table, and when to calculate the add-ons. And which you do first matters at the final outcome. And on top of that, we have the new schedule that the commission has already voted on. So all these case examples are going to show you the difference in the sequence. And sequence A is that you calculate the time sharing, you calculate the add-ons, you calculate a preliminary orders, your step 4, and then you check it against the low income table. So that low income table has the final say in step 5. And then you take the lowest, so it would be the low income table. Maybe if you look at the case examples, we find out that it's the shared parenting usually is lower than the low income table, but it's those add-ons that really matter. And the strength of this approach is that it always protects the low income adjustment. It sets a priority with the obligated parent that they never have to pay more than what's in the low income table if they're eligible for that. The sequence B is the same, except we get to that low income table, then we do the add-ons. So if there's like $1,000 in childcare and they have equal income, he may be, or the non-custodial parent might be getting a low income adjustment. But then there's going to be, and let's say that their low income order is $300, but there's add-ons, they have equal income, then there's going to be an additional $500. So because somebody's got to pay the add-ons. And I use that extreme case example of $1,000 in childcare. And then the sequence option C is something that Michigan does. And to be honest, it's just a nightmare to program. So the case scenarios look at sequence option A and sequence option B. What Michigan does, which is the formula that you like, the Minnesota-Michigan variant. I go Michigan/Minnesota because it's really the same formula. It's just the exponent that matters. Is that they calculate low income adjustment first and they plug that into the shared parenting, and then they do the add-ons. And I'm not really sure what the strength of this is, except it's really hard to write it up in the statute. I have graphed it out for Michigan. Michigan has a different low income adjustment. And sometimes it depends on what's more or less between option B, sequence B and C with Michigan. It depends on how equal their income is and how equal their time sharing is, as far as whether C or B is more with the way Michigan does it. So most importantly, because that was a lot, I added too much information in there, is that in this memo, we focus on option A and B. And really the kicker on A and B is whether to do the low income adjustment last, meaning that those add-ons are considered, that if it's a huge amount, the obligor's low income amount is protected, or option B, where we do the add-ons last. So the non-custodial parent always pays the non-custodial parent's pro rata share of the add-ons, which, you know, could be high. And if you look at the case examples, they start on page 2. And the first case, 4 case scenarios I pulled from the data, the case file data we have. And what you'll see is that in C1 and C2 are the typical DCSS cases based on using the case file data. The low income adjustment doesn't even apply in these cases, just because there's 1 or 2 children. But where you get to the ones that really matter are the scenarios developed from subcommittee members, and the details of these scenarios are in the appendix. It's very interesting to read. I mean, I think these are some real case examples, you know, like there was one case of a children with autism, you know, which it happens, and those add-ons could be substantial. So, and Elaine, I forgot which case scenarios we're going to emphasize.
I think it
in
was,
these ones.
where's the note? You were gonna look at,
I've got it
thank you.
C3, C3A, and C4.
Okay, so C3,
No, I'm so sorry. I'm so
S3.
sorry.
yes,
No, yeah, I'm wrong. I don't have that down. That was for parenting time.
yeah, that is parenting time. Let me see if
Hold
I-
on.
One real quick. Sorry, I was at my office when we were doing this, and obviously those notes didn't make it to my briefcase. Let's do S3 with 1 child on page 3. It's at the bottom. So we have a CP father who makes $3,000 a month, and then we have a CP mother, and this is actually the case that where the child was autistic, and the mother, this was really a sad case scenario, but we know it happens. That mother has very limited visitation. She's got some addiction issues. So they at minimum come to her at 1261. The father's waiting for peach care to kind of kick in. You know, there's always a delay in getting your child diagnosed. And meanwhile, he's paying $300 a month in occupational therapy. And I think there was some health insurance there too, but I cut that out. I didn't see it. So I apologize to whomever put together that case scenario, but so we only have add-ons of 300, and this is just for people that, for the whole committee, that's all you need to know, but my apologies to the person that came up with this thing, and that's what that person needs to know.
that was me,
But,
no problem.
No, thanks, Sarah.
No worries.
So if we look at column 1, if we just look at the NCP share, so this is mom that has her income imputed at 161. Under the existing BCSO, her order would be 242. Goes down a little bit just because of the way the numbers landed with the new Betts and Rothbarth table. Goes down to 229. Some of that is just the cap on the way we do low income. And then if we look at the column 3, using low income option 15OC, that has income imputed at 1261 should never have to pay 240. And then we look at her share of add-ons, 118. So that would bring it up to 347, which is column 5. So if we look at column 6, the first cluster, sequence A, so that low income table is the last step considered. So we're going to go with low income option 15C in sequence A. So that's under column 6. You'll see that the order would be 240. However, if we go to sequence B, where the add-ons are considered last, then that order is 347. You know, and this is a hard one because, you know, those expenses are real. And so if you look at the sequence A, she's going to pay about 20% of her income, so 240 out of 1261, assuming she can get that minimum wage job and keep it. And then if Georgia were to go with sequence B, she would have to pay 350, which is more about 25%, a little bit more than 25% of her income. So that just illustrates what's going on with this case. And there's some more of them here that have that situation. So I'm going to stop there.
Dr. Venor, I looked at that sample pretty carefully, and then I also looked at S2, which is sort of the flip where you have the other parent making more money. I think that would be useful to go over unless someone else had a suggestion. Just to see, or I can just say in short, basically what I found in these calculations is that if the lower income parent is the one paying, that sequence B is not going to work very well for that parent. It's almost like we don't have a low income deviation, but if you use that sequence B in a situation where the custodial parent is the low income parent, it could be really detrimental. I don't know if I'm saying that the right way, but I guess what I was getting from this is if the add-ons are going to negatively impact, or if they're going to be taken away so that they negatively impact the receiving custodial parent who makes less, then is there a way to just apply the sequence in only certain situations, like where the custodial parent is making more than the paying parent, so that mom here who has the drug addiction and can barely pay, we have the one sequence, but for the reverse situation where the custodial parent's clearly making a lot more or making a lot less, I think I'm getting backwards here. Do we follow what I'm saying or not? Maybe not. Maybe if you could go over that other sequence, that would maybe be more helpful than what I just did.
Well, I think you're looking for a rule to make it where if the NCP's income is more than the CP, then maybe go with sequence B.
Yes.
But if and the only thing I'd have to map that out. I mean, it's sort of like running errands when if you only going to make right turns, and then if you have 2 errands, that's easy to do. But if you have 20, it's almost impossible. So the more rules you put on,
right,
the more difficult it is. But we'll go over that case scenario because I do think, Elaine and Noelle and I went through these case examples like crazy on, I think it was Tuesday or Monday. And obviously it's, and it was just painful to read them, to be honest, because these are real life scenarios. So, but I will say that they're not the majority of the cases, what we see in the case file data. So one child, going to S2, I'm providing too much extraneous information. I'm going to stop that. There's one child and there's a CP father again and a CP mother. I didn't notice that. It was supposed to be an equal custody case, but I changed it to a NCP father. Mm-hmm. So so let me state that again. S2, one child, there's an NCP father and a CP mother. They have one kid. The CP's mother is $1,500 a month in gross income, and the father's income is $2,000, so it's $500 more. The child goes to daycare, the cost of which is $600 a month. And this was really good. I appreciate the detail in this because we talked about how much subsidies they would get. And
it was fun to come up with these hypotheticals because I have young kids and also do these cases all the time for our clients. So I was able to pull some numbers out.
Yeah, no, I thought it was very informative to see this. And what we see is that the childcare costs is now $200 a month is what it reduces to. So again, under the existing schedule, the NCP's share would be 401. Now it goes down to 371, and that's just that anomaly for one child. It only happens there. And then if you look at column 4, we're going to add on 114. That's the NCP share of that 200 in childcare. Column 5 shows that would be 485. So if we stick to column 3, where the low income option 15C would be 381, and then we go to column 6, we get 381 in the sequence A, but the reason we get 495 under the sequence B for 15C is we took that 381 and then added column 4, which is the 114. So that comes out to 495.
Jane, is it 485? That's what I see on the document.
It should be,
wait a minute. You know what? I'm sorry.
Yeah, it should be 495 because we're taking 381 plus
Yes, I see it.
114. So actually, if we didn't apply the low income adjustment there, it would be 485. But yeah, that's not the best case example because of that. That would be, yeah. But the big question is whether it should be 381 or the full amount, which would be 485 or 495, depending on
495,
whether
yes.
lower the two.
So if I may add, after what I did with each of these scenarios is that I basically saw what each parent would have left at the end of the day in terms of income after the daycare was paid. And in that scenario, if you applied sequence A, the custodial parent is left, she has $1,681 to support herself and the kids, and the non-custodial has $1,619. And so basically the non-custodial parent's only helping with like $9 or $10 of the childcare cost. And, you know, because she only makes $1,500. And then the far column, the sequence B, the custodial parent at the end of the day would have $1,795 and the non-custodial parent would have $1,505. And so to me, it was like saying the custodial parent has $295 more to take care of all the needs of the child other than the child care, because we've already factored that out. And that just seemed to be more appropriate to me than hurting the custodial parent in that situation where she makes less. And I think that that's what I've liked about some of the states that do look at what the custodial parent's household is versus the non-custodial. And I would think there needs to be, I didn't have a whole lot of time to digest this, but I mean, if a decision had to be made today, I mean, I'd be really uncomfortable with just a decision that would just apply bright line sequence A over sequence B or vice versa. You know, I mean, I just think there has to be some consideration for whether the custodial parent is lower income than the non-custodial parent and whether those add-ons apply, if this makes sense.
I need to clarify one thing. I mean, I like the direction where you're going as far as thinking of their after payment or receipt of child support. The only problem with that is that she's not going to have, or the mother isn't going to have any tax liability, and it's really their after-tax income. Just because of her income, she's going to get the EITC, she's going to get the child tax credit. She's actually going to have more gross income left than what that calculation shows. And he's not going to be eligible for the EITC. He's making too much money and he's going to have to pay the full tax thing, because as economists, we obsess about after-tax income. That's actually what you have to spend. And so really it's hard to, I like the calculation in it, but it's like, I want to go another step further. And
I
think about
agree
their tax
100%. And see, I don't have enough of the tax background, but I actually thought, you know, when I was going through these, I'm like, okay, well, you know, I was also thinking in the higher level incomes, when you have a tax credit for one child of $2,000, that's $167 a month. So if the custodial parent's going to have $167 a month in her bank on top of, or his bank, on top of whatever they have left, you know, that is another factor to consider that I really, and I remember the late Mark Rogers always talking about the tax impact because of those credits. And I don't have the expertise to really, you know, so I guess, so what I just saw was a general trend. I don't know how much at the very low end where that scenario is, where she's only making 1,500, I can see what you're saying, because he's also very low income at 2,000, but I'm wondering if some of those higher incomes on the, like S5, you know, I'm not sure if that was another, no, that was so I can see the non-custodial parent needing a break when they are the lesser income parent. But I just had that concern, but you've addressed it at least with that scenario, and I appreciate you clarifying that with the tax impact.
I have a question. Are we only looking at this as far as low income? Or are we looking at this this would apply across the board in terms of the sequencing and I guess also let me just do this caveat. I'm in the middle of my domestic week, or I'm at the end of it. So maybe I'm overthinking and probably a little frustrated, but when I have parents, the custodial parent choosing, for instance, you know, more expensive childcare than what they had when the couple was intact, or making decisions together, you know, or choosing to put the child in private school and they weren't in private school before, and now this non-custodial parent is being looked at to pay for something that, or they don't agree, you know, private versus public, or the daycare. I guess the court can always make some adjustments, but that's my concern. Like when one parent gets to make those decisions, whereas in a perfect world, intact parents would make those decisions together, even if they're not intact, if they're co-parenting, on what they can collectively afford. So I guess, are we just looking at this from the low income? Because sometimes I have where there's money there, but there's not a decision to, you know, agree to pay that much money for school or childcare when there are other options that are more affordable.
As I understand it, we're only looking at the low income adjustment issue today.
Okay, that's what I wanted to make sure.
Sequencing is all about when does the low income adjustment kick in, before or after the other adjustments. So it wouldn't apply it unless there's a low income adjustment happening.
For one of the parents, even if
For the non-custodial parent.
for the non-custodial. Okay, I just wanted to make sure.
Yeah, low
Well,
income adjustment is about the non-custodial parent.
I should have worn my t-shirt that says, give me a moment while I overthink this, but okay.
I think it's also useful to remind ourselves that in the world of daycare and the hypothetical situation where a parent chooses to sign up for daycare that's extravagant given their financial circumstances, the court has the ability to not count 100% of the child care costs if the court finds that it's not a reasonable amount. But that happens entirely in a different section. It has nothing to do with low income deviation. It has all to do with, does the court think there's something wrong with this child care adjustment amount, and the fairness of who gets to decide which daycare to enroll in. But I think it's also worth remembering that, and Sarah may be the one most likely to remember, I haven't paid for childcare in a lot of years, but it's really expensive.
Right. That's the challenge, because there are places that are very, very inexpensive for a reason. And where, you know, the argument for the non-custodial, or for the custodial parent, for whoever's paying for it, would be that, you know, you have to choose a place that's minimally competent and safe. But unfortunately, the cost for even a place that's on the low end that is minimally competent and safe can be very high. And then, you know, it just goes up from there. And then you get into questions about, you know, making, you know, does this count as an educational decision? Depending on the age of the child, you know, are we talking about a $200 a month difference or $1,000 a month difference? And there are a lot of variables. I've seen courts go both ways with saying, you know, that a parent has the right to choose the childcare situation that they think is best for their child within reason. And also had them say, you know, that this one is unreasonably high for the party's means. So it is complicated.
I understand we're having a conversation. I echo what everyone says about childcare. I am still paying for a little bit of it myself with one elementary schooler and one middle schooler. It's not quite like daycare before they were school age, but even in middle school and elementary school, when they're in the public school system for the day, it's still incredibly expensive. And there are lots of different options. But I would like to see, just because I'm looking at the clock and trying to manage the meeting, Judge Palmer, do you have an opinion on the sequencing options? It's okay if you don't. I don't mean to put you on the spot. I just wanted to ask.
No, I mean, I would say, I mean, if I was king and I had to decide right now, I would say that you should apply the adjustment before. But I mean, I understand. I haven't waded into this as much as I did the other.
Okay, so that's a B, the B sequence.
Correct. Yeah.
Okay, thank you. Okay, Noelle, I saw your hand go up. Did you want to say something, or was that an accident?
Well, I didn't understand him to say B sequence. He said apply the adjustment before.
Yeah.
You mean apply the low income adjustment before the add-ons and Schedule D? Is that what you're saying?
Correct.
Okay, yeah.
Okay, that's B, right?
Yeah, I just misunderstood the way he said it. It seems to make sense to me, because to me, the Schedule D expenses are real, actual expenses. I mean, we know these are expenses that are being incurred for this child.
Yeah, it's not an imaginary. It's a real number.
Yeah, and for us to go in and reduce them somehow is, this is actually what I'm paying.
There is a bill for these things that somebody has to pay, presumably.
Right. Well, I mean, the way the statute's written, right. Echoing Judge Palmer and Judge Williford. I mean, the statute requires evidence of the actual expenses for Schedule D. So,
and again, judges hopefully still will have the ability to go in and do a non-specific deviation under Schedule E. As Deborah or somebody said, if we believe that they're not reasonable expenses, there's a remedy for that.
But, I mean, y'all have all touched on this. I mean, in the real world, these things are all over the place. I mean, people, there's a lot of arguments about whether they're going to this school or that school or this daycare or that daycare, or what the different things are. I mean, I
think Carol wants to say something. Carol?
The only thing I wanted to say is I think in making this decision that we don't lose sight of the fact that child support is for the benefit of the child and for the children. And as a public policy decision in making this decision, I think you have to look at the methodology that is going to best benefit the child. That's all I have to say.
And not the non-custodial parent.
Right. And I will piggyback on what Judge Williford and Judge Palmer were just saying and say, I mean, as I said a minute ago, Schedule D has real actual expenses. However, to the extent that there is a dispute about the reasonableness of the work-related childcare expenses on Schedule D, the judge has to receive the evidence, but can then put in a number that he or she believes to be reasonable, but still have it be in the nature of an actual expense with evidence that supports it. So anyway, just putting that out there. Dr. Venor, I've asked now for Judge Palmer's opinion. It was no particular order. What about, circling back to the way Judge Williford asked it in our most recent discussion, what is your opinion as our expert and economist and, paid consultant on this?
I do think it boils down to a policy decision. As far as the add-ons, I do think the federal requirement is to provide a low income adjustment. And if you take that very seriously, then the sequence A makes more sense. I'm not losing sleep over it though, because when I look at the case file data, and who knows, maybe it's very similar to what I see in other states. 4% of the cases had childcare expenses. 7% had health insurance expenses. So, and DCSS cases. So, and that's all together. So, when we ran it for Alabama, we didn't run it this way for Georgia. It was even less. We had looked at only those that were eligible for the low income adjustment, and only 1% had add-ons. And what Alabama did was they said, you know, we appreciate the issue, but because it's only 1% of the cases, we're not going to complicate things. They ended up doing the sequence A. And then there's one other thing I wanted to say. Oh, with regard to the health insurance, keep in mind that this is what's good for the goose is good for the gander. So it might be the custodial parent that's incurring the childcare expenses. So if you do sequence B, it's going to result in a higher order. But if it's the NCP that is incurring the health insurance costs, which is what we see in the majority of the cases, I haven't run it to see if it's true with the low income, then they're going to get a credit. So that's going to even lower the order amount. So it's a two-way street. I'm going to stop there if that made any sense.
I wanted to let folks know where in the statute the provision is that I referred to that says that the courts already have the authority to say that amount of childcare expense is higher than I think is reasonable. So I'm only going to allow X dollars. It's not a deviation. It doesn't require all that rigmarole that deviations require. It's in the statute, the section about work-related childcare costs, which is 19.615 paren H, like Harry, paren 1, paren capital A, like Apple. And it says work-related childcare costs necessary for the parent's employment, education, blah, 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 that are determined by the court to be appropriate and that are appropriate to the parent's financial abilities and to the lifestyle of the child if the parents and child were living together. So the court, you know, if the court thinks $1,000 a month is extravagant, this family would not have chosen $1,000 a month, then I'm only going to allow the amount that I deem is appropriate when calculating the amount of the child care adjustment. So I figured I'd cite my authority for my earlier comment.
Thank you, Deborah. Okay, so that's a little bit of a mixed bag, but do we, oh, Noelle, your hand's up. I apologize.
Yeah, no, I just raised it. I just want to clarify my understanding from a theoretical perspective for just a second. What we're doing with the low income adjustment in this alternative low income table, I see as a fail-safe to ensure that the final child support amount doesn't exceed 19% of the NCP's gross income at that $1,500 level. And we all know then it phases out, and then it also is implemented at different higher percentage amounts if you have more children. So for me, if that's the ultimate fail-safe, that the studies have said these orders shouldn't exceed 19%, Schedule A, when you do that final test, that fail-safe test, as I called it, after the add-ons, preserves that low income adjustment for the final amount of child support. If you do it before the add-ons, all you're doing is ensuring the BCSO amount hasn't exceeded the 19%. And that's fine, Dr. I'm not going to express my personal opinion on that. I just want to make sure that there's clarity. And Dr. Moore said that's a policy decision, but if we only ensure that the BCSO amount doesn't exceed those low income percentages, add-ons can blow that out of the water, and it's as if there is no fail-safe. I also want to say these are very difficult family situations. Bottom line is there's just not a lot of money. These are difficult decisions, and I just want to acknowledge that.
Any questions or comments following Noelle's helpful reminder?
I'm concerned about the time. It's 11:22, and
Yes.
is it you know, we made a lot of progress on low income adjustment by choosing 1500C. And while I would love to make decisions about the sequence today, it may be that that's going to have to be tabled or pushed to the next meeting. I don't know.
We could also possibly do it via e-vote if
Yeah.
possibly.
Yeah. Because I've heard several people say that they, including Judge Palmer, who we rely on to really weigh in on the low income adjustment issue, that he wasn't prepared to address this today. And so I feel like we should table this and then send some communication out as to whether or not it will be placed on the next agenda, or whether or not we want to do, some email votes on this after folks have had more time to consider it or think about it or delve into it a little bit, because I've
thought about it. I mean, I
Okay.
just wasn't, I didn't spend a lot of time, preparing to lead the discussion on it today.
Okay.
But I mean, I have an opinion, and I think I'm right, but
Well, I was leaning towards B until Noelle just said what she said,
Yeah,
and just being
yeah.
concerned about the feds and making sure that, we comply with that. I mean, Dr. Venor seemed to say it depends on how concerned you are with the feds. Well, I'm very concerned with the feds, but maybe I shouldn't be.
The feds do not say that there has to be a dramatic cut or that there has to be a self-support reserve for non-custodial parents.
It's a
not.
broad, yeah.
It gives the states flexibility to decide how they're going to do it. And it, I think, is a misunderstanding to suggest that it has to be a certain way. The feds didn't say it has to be a certain way. If they did, y'all wouldn't be having this discussion. Can you just do what they say?
Well, I guess I'll say, do any subcommittee members have a motion at this time? If you have a motion, then move. If you don't, then I think we're going to have to move on to the parenting time adjustment issue.
What do you think, Judge Williford, about this? Did you change your mind?
I honestly, I've spent so much time on the parenting time adjustment that I have not delved into the low income adjustment enough to really lead that.
Dr. Venor, you think A is the way to go? Is that what you're saying?
Yeah, I say that, and I mean, with all due respect to Ms. Johnson, yes, the federal rule does give flexibility to how you do the low income, but Noelle was right in the spirit of the reason the feds did it, that low income adjustment should be a safeguard for.
Yeah, as you said, if you're serious about the low income. Noelle, you agree with her?
Yes, acknowledging that this is very difficult. Like, there's not enough money to go around for two households.
Right. All right, then I make a motion we adopt sequence A.
Anyone want to second it?
You're not willing to?
I'll second it.
No, I'll second it. I'll take myself off mute.
Katie will second it.
Okay, we'll do the same. We'll call for a vote, and please do your same hands.
I can't figure out how to do the
It's just across the bottom.
The virtual hand.
Says raise hand.
Yeah, and I'm seeing everybody except Sarah. So Sarah, you look, you're enough. Okay, yep, it actually passed unanimously. Now also remember that These are recommendations to the commission. The commission now has to do
yeah.
this all again. So we're gonna have a full discussion, sort of de novo, if you will. But this will go on, as noted, as a recommendation to adopt 1500C with sequence A per Dr. Menor's report. Okay, very good, thank you.
Thanks, everybody. Okay, let's move on to the parenting time. Well, okay, am I reading this? Elaine, I might need help with this executive agenda. I have the conversation about the term custodial and non-custodial next on the agenda, but I'm kind of thinking.
No, if you look at A, they lump the low income deviation and the parenting time
Oh,
deviation
okay, good.
together.
Okay, all right, good. Okay, I
Yeah.
was like, wait a minute, we really
We're
need to
still on
spend our time
A.
on here. Okay, good.
We're,
Sorry,
we're
sorry.
on parenting time. We're good.
All right, okay, yeah, that's what I was trying to get to parenting time. I apologize. It's the second clause of A. All right, so Judge Williford, I'm handing it to you.
All right. So I'm going to talk in super speed. We have talked about parenting time adjustment. And when I say we, I'll just talk about both the study committee, the commission as a whole, this subcommittee for years, right? And literally you could take it all the way back to the beginning of the way we do child support now, that parenting time adjustment has been an issue. And so I want to just start by saying that today is a huge day. And I hope everybody recognizes what a huge day it is, because both for low income and particularly for parenting time adjustment, this is an issue that has been worked on for decades, almost. And we're making some real hard decisions today, hopefully, about what's going to be presented to the commission. And the commission looks to the subcommittees to do all the work and to make the recommendations. And so oftentimes, almost always, what the subcommittees recommend is what gets passed by the commission. So today is a big, big day. And, I kind of woke up this morning thinking about all the work that's gone into this years before I even sat on this commission or this committee, and just really wanted to take a moment to recognize what a big day that is, what this is. With that said, we have talked and talked and talked. And so without going into a whole nother conversation about which formula Georgia is going to propose for parenting time adjustment, I want to just start by saying, I think we left off at our last meeting, and in fact, our last couple of meetings, with the idea that Georgia's proposed parenting time adjustment would be what we have to this point called the Minnesota-Michigan formula, that I now want to call the Georgia's proposed formula, so we can stop using Minnesota and Michigan. Okay. But is everybody in agreement? In fact, let me just say, is there anybody who wants to discuss that further? Or can we go ahead and make a motion and put that to a vote that Georgia's proposed parenting time adjustment would be Minnesota, Michigan? And if we can agree on that, then we can move to deciding on an exponent to use in that formula, which I think we need to hear a little bit more from Dr. Venor. And she's done some more examples for us to go through on that, and then put that to a vote. So that may be confusing, but I guess the direct question is, does anybody want to discuss further which formula, not the exponent, but which formula Georgia would propose for parenting time adjustment? Raise your hand or speak up. Pat, your hand is up, but is that a vote from before? Okay.
That's a vote. Sorry,
Okay.
let me take that down.
All right, I don't see any hands and nobody is speaking up. So I am going.
Oh, I hear.
Judge Williford, I'm prepared to make the motion as soon as you're ready.
All right, Katie, go ahead.
So I would like to move for Georgia to adopt the Minnesota-Michigan formula, retitling it the proposed Georgia formula, and take a vote on that so that we can then begin our discussion on the exponent.
All right, all right. Christina, that was you?
Yes.
Okay. All right, so let's vote then.
The yeas have it at 9. It's a unanimous vote in favor.
All right. I'm very excited about that. All right, let's move on then. As we know, with that formula, there has to be an exponent, and there's been some discussion about whether or not it would be 2 or 2.5 or 3 or somewhere in between all of that. But let's then turn it over to Dr. Venor to go through some examples and discuss her opinion as to what would be the best exponent for Georgia under that formula.
Okay, I'm going to use the September 18th memo, and I'm looking at page 6. And there's a table, it's labeled Table 2, Equal Time Sharing. So each parent has 182.5 days. And again, you see the column 1 and the column 2, which are just the NCP's share of the updated BCSO. And I know that term NCP is a little uncomfortable for this scenario, but we're just going to use it anyway. And we're just going to keep that terminology. And I realize that's on the table later as far as what term to use. So in case C1, you'll see that the order amount, column 2, using the updated table would be 238 if there was no time sharing adjustment. And we have a case that's equal income, equal custody. And in this case, we have each parent is at minimum wage 1261.50, and that's going to zero out. If we have equal income, equal custody, it doesn't matter what exponent you use, it's going to zero out. And I will say that because you're going to have the clause that they must have a parenting time agreement. You know, I don't think the C1 is going to happen very often, even though this is a 20-25% of the DCSS orders. Case C2, we have the NCP with more income, almost twice as much. If there was no adjustment, the order would be 460. And it doesn't matter again, and this is because of that nonlinear shape. It all results in the same amount when there's equal time sharing. So you'll see it 114 regardless. Now, case 4, and we skip case 3 because there was an add-on, so it gets a little bit more complicated. We have the CP having more income, 6,000. And if we use the new updated schedule, it would be 312 without any time sharing adjustment. It doesn't matter what the exponent is. The parent with more income, when there's equal custody, is going to be the obligated parent. So in this case, it would be who we deem the CP income. And because her income is about 67%, 66% more than his income, she's going to owe the NCP, what we call the NCP, $291. So this illustrates no matter what, you can flip it and that the exponent doesn't matter. Now, if we look at table 3, and I'm just going to walk through case C3A and case C3B. And here we have non-custodial parent has 140 overnights. The CP has 225 overnights. So the NCP has about 38% of all the overnights time sharing. So it's substantial. And we look at case C3A, the NCP income. He has more income. He's got 4,254, so 58% of the combined income. The CP has about 3,000 income, so 42%. There's no add-ons. And so if we look at column 2, if there was no time sharing adjustment under the updated BCSO table, it would be 638. And here you can see where the exponent really matters. The exponent of 2 is 332, exponent of 2.5 is 381, exponent of 3 is 425. Now where it gets interesting is we look at the case C3B, and we did something a little funky here that you're probably not going to see that often. The NCP is actually paying the childcare costs of 1,000. And we did that just an extreme example, just so you can see how all this stuff can flip. So the NCP is paying that out of pocket. I mean, in reality, it'd probably be more the health insurance, but he probably wouldn't pay $1,000 in health insurance because you have that reasonableness of cost. But the point is to see how who is the payer can flip just because of add-ons. And so in case C3B, because he's paying that $1,000, the CP share of that is $420. So he should get a credit for $420. And if we look at column 2, before any adjustment, it would be $638. But then if we use the exponent of 2, who we deemed or are calling the custodial parent actually owes the non-custodial parent $88. Because if you look at that 332 above there, now we have to take that 420 and we have to give a adjust for what the CPO is for that, and that's $88 is the difference. If the exponent of 2.5, it only is $39. And then with an exponent of 3, it's $5. Granted, that's an extreme case example, but it's used to illustrate how it can be flipped with add-ons. And with regard to what I think is appropriate, I prefer the exponent of a 2. I think it tracks closer to other formulas such as the Indiana and the Oregon and the cross credit, which all have a theoretical basis. Well, the Indiana and the cross credit do. So that's the exponent that I prefer. I'll stop there.
I'm so sorry. Can you repeat which one you said you prefer, Dr. Benor?
The 2, so the first one, exponent of 2. The disadvantage of that is that no state is using that at the time. Michigan is proposing to go back to 2. Michigan used it in the past. Michigan went from 2 to 3 to 2.5, and now they're thinking 2.5 is too much. They're going to go back to 2, or they're proposing it. And then Minnesota uses 3. So if you were to go with something that a state is using, then it would be 2.5. I would definitely go with the lower.
Well, it's clear that to me that it's either 2 or 2.5 or somewhere in between, but it's not 3. But does anybody have, just to kind of cut down on discussion, does anybody have a desire to go with 3 or talk about 3, or can we limit it to, is it going to be 2 or 2.5 or somewhere in between?
I'm not on the committee, Judge, but I think 3 is good. I like 3 for what it's worth.
Okay. And tell me why.
Because this is already, well, these probably aren't the greatest reasons, but I think it's already going to be, there's going to be a lot of adjusting that could happen at the same time. And Minnesota has been okay with 3. That protects, I shouldn't say protects. It offers a very fair adjustment, in my opinion, to the non-custodial parent. They are getting a parenting time adjustment. They're getting it at a very low level, because it's a gradual curve, but it's not, especially with the low income adjustment that was just proposed. I think it could be too drastic, in my opinion, I'm probably, I just really liked Minnesota's. It seems like it's a fair adjustment, but it's not jumping to the biggest adjustment that we could possibly give, if I had to narrow it down.
And Michigan went with 3 following Minnesota, and then decided, Dr. Venor, that 3 was too much, and then went to 2.5, and now they're discussing going from 2.5 to 2. Is that accurate?
Right, except Michigan wasn't influenced by Minnesota, but yeah,
Okay.
they jump around a lot.
All right.
I think it might be useful to look at page 9 too, where there's another table. And this is 75 overnights, the NCPs, and the CP has 290. And I can't remember, I'm looking for her, who came up with that somebody used a decab They said that that's kind of a time sharing arrangement that they use. So if you look at case C1, and so the obligor, if you column 2 would be how much his order would be 238 if there was no time sharing adjustment. And if you go with an exponent of 2, he gets a $30 adjustment per month. If you go with exponent 2.5, he gets a $16 a month, based on that difference between 238 and 222. And then exponent of 3, he gets essentially $8 a month. And that's the reason Michigan went down from exponent of 3 to an exponent of 2.5. So these are equal income. So he's got the child 75 overnights, and it's essentially saying you only get an $8 break when Michigan was at 3.
Yeah, Jane, can I just clarify? So what you're saying is, if with the exponent of 3 at 75 overnights, we divide that into 12, the NCP has the child, let's just call it 6. It's 6.25 overnights. And the adjustment would be, you get $8 for those 6. Versus at an exponent of 2, there would be a $30 adjustment to account for that amount of parenting time, the 6 nights.
Mm-hmm.
So we've got to decide, what do we think is more appropriate, the $30 adjustment or an $8 adjustment for 6 nights?
And that's 2 versus 3.
Yes. And 2.5
Yeah,
was
and
at 60.
Yeah, and I think case C3 and C4 are more realistic based on what we saw in the case file. Case C3 and case C4, I pulled those cases where there was a deviation for time sharing. We rarely see a deviation for time sharing in the scenario where the incomes are at 1261, which is C1. So case C3 and C4 would be more appropriate. And to save space, I didn't include the CP's income in those cases. And let me give them to you. So in the C3, so the NCP income is 4254, and then the CP income is 3060. And then in C4, the NCP income is 2300. And then I picked a case example where CP income was more 6600, but we didn't really see that too often. A footnote in here about those 2 cases. About 16% of private cases had a deviation for parenting expenses. Explicit. There might have been more, but they didn't say what the reason was for the deviation. One had childcare expenses. About 1/3 of those 16% have health insurance. It was typically paid by the NCP, and I took the medium income for those 16%. And then for case scenario C4, I looked at those where the CP income was more than the NCP because I wanted to illustrate what would happen. That was about 3% of the cases that have 3% of the 16%. So it's very uncommon for the CP to have more income. So just to provide more details on which ones are more typical. I'll stop there.
Well, I mean, there's the 2, there's the 2.5, there's the 3, or there's anywhere in between. I mean, there's nothing that would keep us from saying, 2.2 or 2.3 or, but I guess the bottom line is the higher the number, the less of adjustment there's going to be. We've hired Dr. Vanor, who is our economist, who has suggested that 2 is the way to go. But we also know that there are states that are doing 2.5 and 3. There are currently no states that are doing 2, as I understand it, Dr. Vanor, is that correct? Although one is looking at going back to 2. And piggybacking on what Judge Palmer said earlier and what I think is realistic, you know, this is something that we have to get the legislature to buy into, and you're going to have, you know, politics is going to be involved in this in terms of, you know, if we can make it, you know, if anybody can swallow it.
And you keep in mind too, Judge, that there was it last year or maybe the year before, there was a bill to make 50-50 parenting time a presumptive norm. I mean, so there is a big constituency that's very interested in this. I know y'all know that.
Yeah.
But I mean,
and I'm all for that, by the way, but I'm trying to keep politics out of this. But I just think it is important to recognize that this is not something that we get to pass. The legislature's got to pass it. So, does anybody else want to be heard on which exponent is the right exponent to suggest to the full commission for this formula? Katie?
I think 2.5, excuse me, of course, then my voice goes out. Pardon me. I think 2.5 is the right exponent for a number of reasons, including that we have, you know, evidence from sister states and what they've done and that they are using it. I think with respect to the notion that the legislature has to pass it, you know, I don't know, who knows what they're going to do. I do think there is a big, you know, lobbying push to see this change. But I also think that that there are legitimate concerns, and certainly the Parenting Time Study Committee heard from many people who were concerned about the notion of incentivizing parents to seek parenting time based on finances as opposed to what was genuinely in the best interest of the children. I also think that while I am not by any means suggesting that we should do something in anticipation of adjusting it down the road, I don't like that way of thinking. But I also think that that if Georgia finds, like possibly some of the other states have found, that the exponent isn't quite right, I think that is an easier change to make to the statute than it is to put in a parenting time adjustment in the first place. I think we're talking about making the big change now, and if we find it doesn't work, I think we will not have to put in the years of work and the effort that we have done at this point to tweak that in the future as needed. Just like we have, you know, the economists look at our BCSO table and do the economic study and determine if the BCSO table is okay, and that's not. I mean, they put the work in, but that's not nearly the big deal that it was in figuring it out the very first time. So to me, this is an appropriate stepwise way to look at it. I think it does some balancing. I think to Carol's point earlier, you know, our overall point should be best interest of the children. You know, and, you know, it might sound like a cop out, but I find it to be very real in my practice. You know, when a judge feels like the number doesn't pass the smell test, he or she is not afraid to use their discretion in making adjustments as they see fit. So if a judge feels like the parenting time amount and the dollar amount of child support under the circumstances of a given case in front of him or her, you know, doesn't work, I've seen just many judges address it how they want to in that circumstance, and or the parties do it in their negotiations. So to me, after all these years of work, I think 2.5 is the right exponent for Georgia right now.
Anybody else want to be heard?
I guess.
Well, I rarely disagree with Katie, but my concern is that, again, just looking at, say, the example that Noelle mentioned a minute ago, six overnight, 6.5 overnights, $30. I mean, you're talking about $5 a day. And that was at the 2.0 exponent. It's taken us 17 years to give a parenting time adjustment period. And even at 2.0, it seems drastically low to me. And I just am concerned. I hear what you're saying, Katie, that it'll be easier to change things in the future, but it took 17 years to get a parenting time adjustment, period. So I'm not convinced that it's something that can easily be fixed if we go too high on it, or how many years we do go too high. And then in terms of, having been a family law practitioner for almost 20 years and a judge for 3, I think it's rare that judges deviate unless it is something very close to, equal custody or something. It's unusual that we see judges deviate from that. And so I can't rely on that to make sure that it's adjusted properly. But
if I may, my thoughts about the highlights that Noelle made about, $30 versus, some other amount for, 6.25 days would be, and maybe this is just my accounting brain sort of kicking in. While I understand that the non-custodial parent will have some expenses related to those 6.25 days, and if you break it out by the day, if it comes out to $5, I get that feels like, well, I'm not sure I feel good about that. But I also think that the non-custodial parent's expenses for those 6 days that the child is with the for the custodial parent, the 6 days that the child is with the non-custodial parent, I don't think their expenses decrease appreciably for those days. And I certainly don't think they decrease by, more than a couple of dollars a day. I don't think it changes even the grocery bill in a material way for when the non-custodial parent's time is that limited. So I think it's appropriate for the parenting time deviations not to really start to feel like they're having a significant financial impact until the time is greater, because I think that's the reality of shared parenting. I think that call it the sort of overhead component of parenting. I don't think it changes that much until there is significant parenting time. So I think it's appropriate to have the parenting time deviation be pretty nominal when there's only a handful of days a month with the non-custodial parent.
Carol, you had your hand up.
Well, I guess what I want to say is that's the whole point of the exponential formula in the first place, is as you increase time, you get a much greater share of the BCSO into your column if you are the non-custodial parent. So to some degree, as to the 2.5 factor, I'll be candid, in my practice, I wasn't seeing 79 days. I was seeing a lot of 65-35 and 60-40 splits before I kind of stepped back from an active practice. So in terms of parenting time, and so you're going to have a much greater percentage under the exponential formula of an adjustment. Getting back to the 2.5 issue, we know that no state at present has done 2.0. We know that some states have done 3.0. I don't see any reason why it's inappropriate to go with a 2.5 figure, which many states have used and which we talked about in our subcommittee. And looking at it from the perspective of the fact that the numbers that are being used to create the 2.5, as I understood Dr. Venor's statement several meetings ago, are based upon data from 3 or 4 years ago. And we know that it costs a whole lot more to raise a child today than it did on the numbers from 4 or 5 or 6 years ago. And so in my mind, that mitigates to use the 2.5 standard going forward as a recommendation to the commission, and the legislature, I'm sure, is going to get testimony on all of this, but it seems like a happy medium ground. That's what I have to say. Thank you.
I'm just going to add one more thing. Sorry. So I'm just going to keep pushing towards the 2.5 or higher model. And that is because, again, the committee, the subcommittee, the study committee, excuse me, we looked at a lot of options. I personally did not want to have a threshold, which this accomplishes. So that is already a huge thing. You know, we're not saying somebody has to reach 100 days. So I guess that's another reason why I'm in favor of doing a higher end exponent. And also, you know, when this law passed back in 2005, 2006, I mean, there was still a big public policy interest that's codified in subsection C that we want to give children in these situations the same benefit as children in intact households, which is where why a lot of people, you know, didn't realize that parenting time wasn't adjusted at all. But so I guess that's just another throw in. I mean, it would seem like a fair assessment to give the paying parent an adjustment, but still recognizing that we don't want to adjust what the children are dealing with by giving that adjustment as much as possible is what the statute says. So thank you.
All right, anyone else want to be heard on which exponent we should use for the proposed Georgia parenting time adjustment?
I would just point out that that I think that table 3 is the parenting time described in table 3 is or more, you know, table 3 and table 2. I believe, and Dr. Venor can certainly correct me or staff, but I think that is the majority of Georgia cases is somewhere in there between table 2 and table 3. Well, not table 2. I don't think the majority of Georgia cases is at 50-50, but I think certainly I think we're moving in the direction of more parenting time. So I think table 3 addresses a majority, and to the extent we're headed in the direction of table 2, I think, you know, a 2.5 exponent is going to continue to benefit the more time there is, continue to benefit the non-custodial parent financially to the extent we move closer to in table 2 equal parenting time situation.
Well, I have respect for the Carol and Johanna and Katie and those that worked for so long and for so many years on the actual parenting time study. So I am not going to go against what they're saying. Does anybody have a motion? Christina, you have your hand up. Did you want to say something?
Yes, I just wanted to make a comment regarding so I think that for me, I would be okay with either 2 or 2.5. And I will just say that either way, it's better than what we have. You know, it's definitely an improvement. It's taken a long time to get to this point. Either way, I think we're moving in the right direction. And I will say that from the standpoint of mediation, at least in my practice, I am seeing a lot more moving towards equal parenting. And so again, any type of adjustment, again, like to Katie's point, when you look at the tables, the one that deals with equal sharing in table 2, either way on exponent 2 or 2.5, you end up with the same result. And again, from my perspective, I'm seeing a lot moving towards that direction, at least what parties are willing to agree to in mediation. And even table 3, which is, again, more than with the 140 overnights to the non-custodial, is not a huge difference between the 2 exponents. So, you know, I think that what we're doing, you know, either way is of benefit to, you know, to the parents and to the children. I don't think it's, you know, that, I guess what I'm saying is not, either way it will be great. It's not a huge difference when we're looking at the actual tables that go to equal parenting time. I think there is a bigger difference when you're looking at the lower number of nights. But again, from my perspective, when I see this come into play, it's because when people are really wanting to get more equal parenting time.
I'd like to make a motion that we call the question.
Okay. And you want to, I think the best way to do it is call what question? The 2.5?
Yes.
Okay. Anybody want to second the 2.5 exponent? Katie seconds it. All right, let's vote.
All right.
Oh, Judge Palmer figured out how to use his raise the hand.
I know, I'm so happy.
And I've got to go to another meeting.
Too.
I had two quick things that I wanted to do, but if we don't have a quorum, we won't do it.
We have
Will it-
seven of them.
will me leaving break the quorum?
Can I just say, I think we have 7 so far for approving, but we have 2 abstentions. I can't see Representative Abstration and Judge Colbert.
All right.
So we can either say it
Representative
passed or 2
Abstration, Representative Abstration had to leave the meeting for
Yeah.
a bit. So that's why you're not seeing him.
Okay,
Do we still have quorum if we don't have abstration?
Yes, we're now at 8.
We're at
Okay.
8. Okay. With Judge Palmer, we're at 8.
Judge Colbert, are you with us?
So you need me?
Yes.
Yes, we're ready for your vote.
He votes yes.
We're good with a quorum of 8 and all 8 approving.
I hear some noise from somewhere. I'm not sure where it's coming from. Okay.
Okay, we have a quorum of 8 with all 8 approving.
All right. Judge Palmer, can you give us like 2 minutes?
Yes.
Okay. All right. Let me just ask this. And again, thank y'all so much because that was huge. Definition of parenting time. Here's what I'm going to move for. And this is a motion for the definition of parenting time. And I believe that this is where we left it off favoring this definition, but I want to read it. Parenting time shall be determined by calculating the number of days a parent spends with a child in a 2-year period for an annual average. Days for purposes of this section is A, the total number of overnights a parent spends with a child, or B, in circumstances where a parent has shorter but regular and recurring daytime periods with a child, the total hours of parenting time in the annual average divided by 24 hours, including any hours spent overnight if applicable. So that was the Oregon definition with a tweak based on what Johanna and some of the others had suggested we do for these sort of irregular parenting time periods and unusual situations. Is there a second on my motion to adopt that definition of parenting time?
I will second it.
All right, let's vote on that.
Again, we're just shy of Judge Colbert, but I think it passes with 7 out of 8.
Okay.
1 abstention.
All right.
She
And
had to go back on the bench.
Yeah.
all right, the last thing I will say is I think we discussed, and y'all correct me if I'm wrong, that it was going to be very confusing if we left on Schedule E things like parenting time deviation or low income deviation, because there is going to be this confusion. We've already built in an adjustment now.
Right.
And then if we use that language on Schedule E as a deviation, that would create a lot of confusion. And so in order to give judges discretion to still be able to deviate, they could still go in and do a non-specific deviation under Schedule E and then explain why they were deviating. So I'm going to move, unless somebody tells me that that was not the understanding, I'm going to move that to remove the current low income and parenting time deviations from the statute altogether, allowing judges to still retain discretion to apply a deviation by selecting the non-specific deviation, providing findings of facts as to why the presumptive is inappropriate. So is there a second on that motion?
I second.
All right, Pat seconds that. Let's put that to a vote.
Yes, again, passes 7 out of 8 with 1 abstention.
All right, wonderful. We have accomplished so much work today, y'all. Let's give all of us a hand. And I think that we have a lot now that the staff and Holly Carter can work on before our next meeting. There are some things we didn't get to, but what we did get to is huge. And I think that gives them a lot to work with. So our next meeting, Elaine, is when?
It will be on October 3rd at 10 a.m.
All right. And that's our statute review subcommittee, right?
Correct.
And then the
And
full
may I-
commission. I'm sorry.
Sorry, keep going. Full
And the
commission
full
meeting, I apologize.
commission meeting is when?
November 17. It will also be at 10 a.m. and it'll be a hybrid.
Okay. All right.
And don't we have
Anything
so we
else?
have a November meeting scheduled too for this subcommittee? November
No,
2nd?
yes, November 2nd
At,
at 9:30.
all right. So the subcommittee, the statute review subcommittee meetings coming up are October 3rd at 10 a.m. and November 2nd at 9:30 a.m. Make sure those are on your calendar. And the next full commission meeting is November 17th at 10 a.m. and that's a hybrid meeting.
Correct.
All right.
And may I
Anything
ask-
else?
Yes, staff, can we circulate a vote to approve the minutes from our last meeting electronically?
Yes.
Well, we're all here. We have a quorum. So
Do we?
all in
Bill?
favor of approving the minutes from the last meeting?
Okay. Come in.
Does that do it to save y'all that work?
Yes.
Good thinking.
All right, those are approved. All right, thank
Thank you,
y'all
Bill.
for agreeing to stay a few minutes over to get so much accomplished today, and we'll continue this hard work. Katie, anything else from you?
No, Judge, thank you.
All right, thank
Thank you.
y'all. Have a great day.